Good morning, Sat Sri Akal, Adab, Namaskar. Bungalow owners, this series is continuing with most of the cases which have either been in a format of PP Act resumption. So this case actually never came to me directly from the bungalow owner, but it flew into me through a bungalow owner's file in reference. So this is bungalow number 9, Victoria Road, survey number 214, having a land area of 3.25 acres of Shri Ahmed Haji Umar, Zafar Sattar Umar, Nafiz Ahmed Umar, all presently living in 313 MG Road, Pune. Now what is this case? This is a beautiful case which was finally fought under the resumption. His bungalow was resumed, and we'll gradually talk of the case, but I'll just read a brief given by the defense estate officer regarding this case when a legal opinion was sought whether to file an SLP or not. This bungalow was on hire with the army, and it was on hire with them from I think way back in 1923. Bungalow number 9, it was a grant given under GGO number 260 of 7/5/1838 to Shri Ahmed Haji Umar, holder of occupancy, and the same was hired by the Defence Department with effect from 25/9/1935 on a monthly rent of 200 rupees. The bungalow was finally resumed in 1970 with a payment of 14,200 and something was given to them for the value of the structure. Simultaneously, even an offer for arbitration was given by appointing an arbitration committee. The HOR was agreed from this resumption notice. As everybody, he filed a civil suit number 1516 of 1970, which he subsequently withdrew because of his notice under CPC 80 was not given, and he was allowed to file a fresh suit. He filed 1097 of 72, and after serving an 80 CPC notice to the department. So the court upheld in 1979 that the notice was illegal and void. The Union of India then filed an appeal 175/1980 in the District Judge Pune, which was dismissed in 1982. Thereafter, Union of India filed the second appeal 18943 of 1982, Bombay High Court, and on November 1982, which was also dismissed summarily. Now the HOR, Haji Muhammad, because this bungalow was on hire as per the 1935 order, he filed a suit for possession through his case 203 of 84. Now the bungalow is not in possession, but this suit had some technicalities, and he did not declare everything about the facts of this resumption. So this degree was taken by him, and an ex parte order was given to him on I think March 1985, and it was told handing over. So this ex parte order, there was an application moved by the department to be removed and let them to be present. So this application was dismissed. Finally, the suit was dismissed, and in 1990, for non-payment of rent, the possession was said to be handed over to the bungalow owner, which meant was owned by Haji, Mr. Ahmed Haji. So how did this entire working came up? In the meanwhile, Union of India had the matter of resumption of property and SLP bearing number 6438 1986. Second appeal and small causes case, ex parte judgments, everything was in place. And it went up till the Supreme Court, and finally in 6438 of 1986, the department had asked for a stay, and on a similar judgment, and the SLP, the Solicitor General, states that Union of India would seek dispossession of the respondent's occupant from the property involved in accordance with law, and if need be through civil court by filing suits in case such steps are taken. Any observation made by the High Court which would tend to defeat the remedy sought would not stand in its way. On such stance, the Union of India Civil Appeal as well as SLP stand disposed accordingly. So finally these proceedings came up regarding possession, and then finally these suits were filed 203 of 84 in the small causes which was already running. So affidavits were filed. 2008, the bungalow owner again filed a civil appeal 623 of 2000. The appeal got dismissed. Being agreed by this district court, 2008, Union of India filed in the Bombay High Court. The CRA was dismissed. The SLP was before the Supreme Court, it was dismissed, SLP 16345, which I just talked of. In this entire happening was happening to a parallel case called 17 Elphinstone Road, Pune, where the HOR had filed a suit in the Supreme Court after the resumption of 1971. So this case came back, a resumption was quashed, possession also was said to be given. Now whether the bungalow owner is in possession of the bungalow or not, because, why am I asking? Because in this during process, the Shri Ahmed Haji Umar's pedigree has been brought into the case. I have these cases with me. I would like to read them. Till the 1972 case, he was aged about 70, and later when these cases moved on, in 2000 also his legal heirs had come in, Zafar, Sattar Umar, Nafiz, Ahmed, Omar. So people were flowing into this case and they were all living in one part of the property. Who are the owners? I will read into it. First appeal you had this Haji Ahmed Haji Umar 877, yet up to there. So now what did the department do? The department initiated a PP Act in 2001 on it, again under section 4. It issued it to the HOR of 17 Elphinstone Road also, and through Shri Kaiksroj, Kawasji, Framji and others. The Honorable White and High Court writ was filed by the owners of this PP Act, and AIR 209 NOC 2980 Allahabad, All India Bombay, Allahabad, Bombay dismissed the writ petition. Okay, fine, now you cannot come in a PP Act in a form of a writ. If you have to do it, let's not define these words, public premises, from the word belonging to and to the owned by. The differentiation was defined on these two suffixes, and this 17 Elphinstone Road's writ was dismissed. So everything like this was going on. Even the Director General had to take a legal opinion in this case of Ahmed Haji Umar from the law branch of the Government of India. The legal affair, again, after reading the whole facts, findings regarding possession as well as resumption, came down to the conclusion that it is, even if we file an SLP, we will not be able to. There are very weak chances or very less chances that the government may win on to it. So this case kept going on. Now, we have to understand this case. What is this case? Lower court. I will read this suit when he was filed after the resumption notice. He didn't file a suit for declaration. Again, he filed a suit for injunction. Friends, this is very important. So but he pleads in his second para that I am the absolute owner of bungalow, outhouse, trees, garden, fences, etc. situated at so and so. A bungalow area, he says. Now here he brings that there is a registered lease of 25th November 1928, certified at Exhibit 58. Now this lease, now the owner is not aware of this, but in this lease is under the House Accommodation Act Section 7. If this case is with me, he is the owner of the property. If this lease is with me, I declare him that nobody on earth can take him away from this property. But gradually, this lease is asked to be upgraded on 25th September 1935. But the very good part in this lease is it's written that he is the owner of the land, trees, passage, easements, and everything like what general language is. So this lease under the House Accommodation Act, original as Exhibit P58, was his savior. So this case goes on and he pleads a lot many things. He's even pleading whether this order of 1838, which is written in the manual, is a statutory law. The notice is very arbitrary. So he even talks this property he inherited in 1934 after a partition deed in 1968. Now here he says the original owner. Who was the original owner? One Haji Omar and Mr. Ahmed Haji Omar inherit the property in 1934. Now gradually this property went down, so there's some history, facts of the pages are speaking. Now most interesting in suit for injunction. Does the plaintiff prove that he is the sole owner of the premises in dispute? Yes. Now this is where I am unable to understand. I have come across a number of cases. The cases are being filed on injunctions, cases are being filed on possession, and an issue of ownership is being driven into it. Because the pleadings are as such. Because you don't file a suit for declaration. So what are we doing? What is the entire system? I find this quite absurd that why does the lower court make an issue in an injunction suit which is on ownership? It should be a suit for declaration then. But well, that's it. Whether the suit is bad for so and so. There were some about 11 issues made in this case. And whether the plaintiff proves. One very good issue is that does the defendant prove that the property was resumed as it was permanently required as stated in para 7 of the written statement Exhibit 34. This is very important. So you have to be very clear how to get your issues made. So issue number 129, real question of decision, the sole owner of property, old grant, predecessors. The department is unable to prove, it is only hanging on a journal land register as Exhibit 66. And 70, nowhere is the government trying to bring in something, and the plaintiff is entirely playing on his lease deed, which really clearly reads that was treated as the owner of outbuilding, grounds, garden, trees, fences, hedges, ditches, wells, easement, and apparent however to the said dwelling house and premises belonging or usually held or house and premise belonging or usually held enjoyed therewith from Bungalow number 9 Victoria Road, Pune. So these kind of documentary evidence were actually saving him, and then in his pleadings he even and the judgment bought Tamu, Firoz Telmuga and Anklesha's H.C. Visista judgment, and we have this journal orders of 1838 and finally 1832. And yes, whether this land could be used for public purpose or not, and finally so it is to be held that the plaintiff has proved his sole ownership over the sued property. I record my findings of issue number 1 and as said above. So the court orders everything in favor of the owner. 1980 he goes into again. So the learned trial court and injunction restraining. Now here the law point in the appeal is, the only point that arises for my consideration is whether the appellant have established that the suit land in fact had been granted to the plaintiff's predecessors in interest on old grant tenures basis so that they could legally claim the resumption of the said land by issuing impugned notice. Now, court is mixing the word old grant or new grant with the resumption and the GGO. Where in any of the GGOs 1836, 1832, 1838 is written that it is an old grant? Nowhere. It's written a grant. Where and anywhere in 1765 order or 1795 order or 1801 GGO orders, it is written that we were old grants or new grants. So we have to understand why is the court interpreting this word old grant with the suffix old under the Grant Act or the Crown Act 1894. That's the problem. We are unable. This bungalow owner, I don't know whether his wife Malik Ahmed Umar, Sattar Ahmed Umar, Zubeda Zakir Gaya, Rashid Umar, Nafia Ahmed Umar, all residing in house number 313 Mahatma Gandhi Road, Pune. This is a marvelous case because his original lease of 1925 says under section 7 of the House Accommodation Act. So that means in Pune, when the House Accommodation Act 1902 was notified, this bungalow fell into that peripheral and there is a plan of it. Please, Pune bungalow owners, I know you all are very highly educated. You cannot define old grant, I know this much. You cannot find your House Accommodation Act. Some people are looking for Mehta's committee report of 1910. It's of no use. He culminates because he was given an assignment for Belgaum, Secunderabad and Pune. After the list, he says that all lands in these cantonments belong to the government. How do you fight that? Don't bring such evidences. We need to fight on the facts, our documents. I need somebody to fish into this owner, bungalow number 9, and I can bet this is an extraordinary case if this lease agreement is there. Once again, we were old grants, never converted into new grants by the British, and finally we were taken within the regime of the Cantonment Act 1864. Thank you. Good day.